My name is Jeff Akins, and I'm chairman of the Mentor Committee for the San Antonio Bar Association. And today is July 20th, 2010, and this is a meeting of the Mentor Committee. It's our program that we have each month, and it is after hours, and it is at the conference room of Langley and Bannack. And I also want to thank Esquire Deposition Services for filming this. And we are before a group of the Mentor Committee. About 15 people here are watching us. And today we're going to have a conversation, or I'm going to have a conversation with CharlieButts. And we will learn more about Charlie as we go on, but that is the setting for this. Good evening, Charlie.
Pardon me?
Good evening.
Oh, how you doing? Glad to see you, Jeff.
How are you feeling?
Feel me?
You're feeling good, and you're feeling very steady.
I'm in good shape.
Okay. Well, a lot of us, I've only recently met you, but a lot of people in the room have known you for many years. But you and I have gotten better acquainted here in the last few days getting ready for this presentation, haven't we?
Absolutely.
And the main reason you're here is you've been licensed since 1949.
May the 10th, 1949.
You're also a mentor on this committee.
Oh, yes.
So we just want to learn from you today, and I guess we'll just start at the beginning and find out how you got into the law and how is it that you picked whatever field you went into.
I started out as a chemical engineering student at Texas Tech until I got to calculus. And I decided that I better not design any chemical plant that'd blow up when they threw the switch. So I had some friends that were lawyers. Mr. S.A.L. Morgan was general counsel for Texaco, my next door neighbor there in Wichita Falls. And I got to talking to him, and I talked to my dad, who was in the furniture business, and I decided, well, I'm going to become a lawyer. So I went into law school before the service, pulled out, went to the Air Force, came back, and went to Texas University, got my license, and here we are.
Well, now you just celebrated a birthday recently.
June the 30th.
And I also was there at that celebration. They had a cake for you at the bar luncheon.
Yeah, that was very nice.
You were 89.
Still am.
So, are you practicing today?
I've been practicing since May of '49, trying to get it right. Still practicing at it.
Okay. So when you got out of law school, I know that you principally have been in criminal law or prosecuting cases. Well, how did you get into that field?
Criminal law?
Mm-hmm.
Well, I practiced oil and gas, PI, a little bit of criminal law. Moved from Wichita Falls to Odessa to Montana to Midland, Big Spring, Helena, Montana, Fort Worth, San Antonio, and through all of that, I ran into Stanley Kirk, who was a district attorney in Wichita Falls in 1962. And the sheriff had been doing some nasty things, and he wanted to investigate him. He hired me to investigate the sheriff, which I did. We tried the poor old sheriff and sent him to pen for 7 years for forgery. And I said to myself, you know, if I can send the sheriff to the pen, I'll be able to send some of these criminals. That's how I got into criminal law.
So before that, you weren't doing any criminal?
A little bit, not, court-appointed case occasionally. I had one when I was practicing 2 days, old Judge Nelson called me and said, I want you here after lunch. You're going to pick a jury in a burglary case. And I said, I'd like to meet the client first. I'd met him in the jail. Tried the case the next morning using Professor Stumberg's law notes. And the guy was convicted. And I don't know whether it was rightly so or not, but I did a pretty good job. And that was the first criminal case I had. And I had a smattering of them after that, but that one with the sheriff was the number one.
Now, were you, in the years before 1962, were you in private practice by yourself, or did you have other lawyers that you were in a firm with?
Well, I started with Allen, Locke, and Colry in Wichita Falls. They were criminal lawyers and PI lawyers. They admonished me, wanted to know if I really wanted to go into that field. That they didn't think that criminal lawyers and PI lawyers had the best image at the time. I said, well, that's what I want to do. So I went with them, and they were my first mentors.
Were you practicing personal injury then with them?
Yes, workers' comp mostly.
Now, how did you decide to do that after they warned you this wasn't looked upon that well as a profession, PI work?
Well, I had a wife and 2 children. I wanted a job, and they offered it to me, and I took it. I had opportunity to go to Grand Saline to practice with an older lawyer there, but they gave me a nice entree, and I said, well, I'll just take a shot at it, and I'm glad I did.
So it sounds like it was a lot of PI, but then you had other general practice things that you did over the years.
Yeah, we represented the undertaker, one of the undertakers there, and he was indicted for embalming people with pure water instead of embalming fluid. And he was the head of one of the shrine organizations, and Taz Locke and I got an acquittal in that case, and lo and behold, they were having their annual conclave there in Wichita Falls that month, and a few days later, well, he came in and had a stack of programs about like that for their meeting, and across the front was a banner that said, Allen, Locke, and Colry, Lawyers Deluxe. No case too large or small, our best is none too good. And he distributed that program around, and we couldn't stop them, and boy, did they get a lot of kidding about that. But they were great lawyers, pioneers in the PI field.
Pioneers in what way?
Well, they established the hero doctrine for one thing. There was a oil field truck caught fire on the highway just out of Wichita toward Seymour, Texas, and a Good Samaritan stopped and tried to get the man out of there and out of the fire, and he was terribly burned, and they sued, and that contributory negligence went out the window, and they said that it was a humanitarian act and shouldn't punish him for it. That was one thing they did.
So you became a trial lawyer, really? Would you say that? Mainly you were a trial lawyer? In the early years?
I would consider that what I am.
Okay. But in those early years, would you say you were a trial lawyer as well?
Yes. Mm-hmm.
And did you envision yourself as a trial lawyer when you were in law school?
Not when I was in law school, because I remembered an instant when I was in junior high school where I played George Washington. And I was supposed to step forward with the flag, and I forgot how big my steps were, and when they closed the curtain, I was left outside the flag of the curtain trying to get in, and you haven't lived until you have a white wig on trying to get in the curtain carrying a flag. And I just never dreamed that I could stand before a jury and even talk, let alone convince them. But I did.
So how was that for you the first time you had to stand in front of a jury?
I was a little bit apprehensive, wondering if I was going to make a decent impression for my client, but I wasn't scared. I just knew I had a job to do and did it the best I could.
A lot of lawyers they do it, but a lot of lawyers are afraid when they go into court.
The only time I've felt any fear, I was telling Ms. Brown that when I have to go before an appellate court, I'm always fearful of one of the justices saying, well, Mr. Butts, what do you think about this case? And I always hope I've read it or understood it. And that's the only real apprehension I have in court, is when I go to try an appeal, especially before the Supreme Court of Texas. I've never been before the United States Supreme Court, but I'm licensed. But that's where I feel kind of shaky.
Worrying about have you overlooked something?
Well, I'm sure that I have, but I've never suffered for it so far as I know. I may have a client in prison that did, but I don't think so.
Well, you went from doing not criminal work, but personal injury trial work. You went for many years, 1949 at least up till 1962, maybe a criminal case here or there, but in 62 was when you became more immersed in criminal work. Is that right?
Yes.
Did you then decide to become a prosecutor or a defense lawyer?
Well, I had the job in the district attorney's office after I was sent sheriff to the pen, and I was prosecutor for 8 years. I'd always been a campaign manager in various capacities for Senator Ralph Yarborough in West Texas, Wichita Falls, everywhere. In 1964, I took my 2 teenage boys to Austin when he ran, or when George Bush Sr. ran against him, and I handled the North Texas part of it. And then the campaign was over, and I headed back to Wichita Falls to be in the DA's office again, and I stopped by to see the DA who had just lost 3 prosecutors, and he offered me a job that was so much better than Wichita Falls, I moved to Fort Worth. And I became first assistant there, and then the Lord smiled on me, and I met my wife Shirley. And we got married, and in 1966, Judge Archie Brown and I were on the nominating committee of the criminal law section of the bar, and we were in Dallas at the bar convention, and he said, what have you been doing? I said, well, I just got married. I'm kind of wouldn't mind moving somewhere. So he said, you need to talk to Jim Barlow. And Barlow was the DA, and I did. And he told me there was a certain prosecutor, I'm sure some people here know who I'm talking about, but I won't name his name, that was the prosecutor and judge in East Cement Court, 175th. And that he wasn't getting along, and that he was very disturbed that he didn't have a lead prosecutor in that court. So I thought, well, that's too bad. And I went on back to Fort Worth, and I got a call from him. He said, if you move to San Antonio, I'll make you lead prosecutor in the 175th. So he offered me a better deal, and Shirley said she'd come, and so we moved to San Antonio.
Now this was about 1966?
67.
Okay.
December 67. Interesting thing happened there. We're talking about Ms. Brown there about women lawyers. Shirley had been the head of the legal aid there in Fort Worth, and she read that they needed a lawyer with a legal aid here. So she went and applied to the head of it at the time, and he said, oh, we don't hire women lawyers. You made a real mistake. Real mistake. The best lawyer I ever knew.
And your wife, Shirley, went on to become a appellate judge.
She was on the Court of Appeals for 14 years.
Now, was she a judge before that, or did she go straight to the appellate court?
She was teaching criminal law, juvenile law, criminal procedure, evidence at St. Mary's. And she applied for that job, and Governor Clements appointed her. Although she was a Democrat, he saw she was a good judge, so he appointed her even though she was a Democrat.
So at some point you quit prosecuting altogether, right, and went into criminal practice?
I left the prosecution in 1971,
And
and I tried one more prosecution of death penalty case by special appointment down in Rockport. Got 2 death penalties, executed one of them was cut back to life, and I got that appointment through Judge John Miller out of Sinton, Texas. That's the only other prosecution I've done. I'd like to go back to the DA's office and prosecute all these child abusers, but I don't guess they'll ever let me have it.
But if you could get the job right now, you'd go back for those kind of cases.
Sure.
Well, let's talk about why you left prosecuting and went to defending.
I don't know whether you ever heard of Mike Rizek or not, but Mike was a character and a half. He kept on to me in the DA's office to come with him. And I kept saying no, and I finally said maybe, and to him that meant yes. And Ted Butler was the DA at the time, and I was first assistant under Ted, and Ted went off up to, I think it was Detroit, to a seminar, and while he was gone, Mike had a bunch of announcements printed. Mike Rizek, CharlieButts, and not Ron Bird, but I forget his first name, take pleasure in announcing the form of the law firm of Rizek, Butts, and Bird. He put a stack of them on Butler's desk and some on mine, and Butler nearly had a heart attack when he came back, and so did I. So he offered me about half again what I was making in the DA's office, and so I went with him. Stayed about a year, and then I had become very close friends with Judge Anise Saman before he died, and Freddie Saman, who is an absolute great criminal lawyer, offered me to come over there, and I did, and I was with him until he died about 14 years later. Tremendous lawyer.
So how did you like defending criminal cases
I loved
as
it.
opposed to prosecuting?
I loved it. I loved both of them.
Now, you and I have talked about that a role model for each of us is Jerry Spence. And you've read his books, and I've read his books. And as you know, Jerry Spence was a prosecutor. He started out prosecuting cases part-time in a small county. But then he made a switch to where he was not going to prosecute a case ever again. He was going to defend criminals. But he swore off of it. He wanted to defend. But you didn't have that kind of a feeling about it. Is that right?
No, I'm just a lawyer. I like to try the case, try it according to the rules, and let the chips fall where they may. I never did have what I would call a prosecution complex. I'll tell you a quick interesting story about that. Several years ago, there was a burglar and thief and murderer run around scaring everybody called the Thief of Baghdad over on the east side of town, and he killed a man, and I tried him for the death penalty on a change of venue down to Victoria. The jury gave him life, and he went on away, and that was in about 1970. Well, about a year and a half ago, My youngest daughter and I were at Taco Bell up there on San Pedro, and this man kept looking at me, kind of gave me the creeps a little bit. He came over, he's a real tall, dignified fella, shook out his hand, said, "You're Charles Butts, aren't you?" And I said, "Yes, sir." "I'll never forget you as long as I live." He said, "I was the thief of Baghdad." Oh my God, here's a man I tried to give the death penalty and he remembers me. So he said, "Oh, wait a minute." He said, "I'll never forget what you said as they led me out of the courtroom. You came over and put your hand on my shoulder and shook my hand and said," I won't use a man's name, "I want you to know it was just a job that I was doing, and the jury has given you a new life. They didn't take your life, and I hope that you make something of it." He said, "I thought about that the whole time I was in prison. I went to school while I was there. I got myself a profession. I made parole, and I got myself a good job, and I want to thank you." So that, to me, was what a prosecutor should do. We had a prosecutor one time that he thought spitting on the sidewalk ought to be a death penalty. You know, I mean, everything was go to the pen, go to the pen. But that was not my philosophy.
Well, let's talk about victories and defeats. And I was thinking, you know, there's every lawyer, every trial lawyer anyway, has a case that he or she thinks he should have won, and maybe blames himself, maybe blames somebody else, and a bitter defeat. And then there's cases where you got a victory and it was very hard, you didn't know you were going to get it, and you feel very proud of it. I'd like it if you could tell us about one of those, each of those kinds of cases, if you have them. I guess your greatest victory and your greatest defeat, your greatest loss.
Well, the one that I should have won was a civil case in Odessa. There was a dentist that was doing a root canal or something, and he left a broken bit about 3/4 of an inch long in my client's gum. And I had an expert, so-called expert dentist, that was going to testify about how bad it was and what malpractice it was. And I went to trial, and lo and behold, that witness of mine decided he wanted to play golf that day. And he wouldn't come, so I had him under subpoena, and I sent the deputy after him and brought him in and had on his golf clothes, and he didn't appreciate it too much. And he got on the stand, and I asked him the questions that I was going to, and he said, "No, that wasn't the reason." He said it was a dry socket. I'll never forget that term, dry socket. And the jury found against my client, and I was very bitter about it because I had no other witness. I was right in court, and the man had suffered considerably, and that was my worst defeat, my most bitter defeat anyway. Mm-hmm. My best, oh gosh, I've had some successes that I remember. I think one that's so good is one that Shirley, my wife, before she went on the court, we tried a case where a young man had, at the suggestion of his girlfriend, shot and killed her father and started to kill the mother, but he got scared and ran off. And so we put him in a mental institution, and he was juvenile.
Now, you were defending this case?
Defending, so was she. And one day, during the course of our preparation, Shirley came in and said, "Look here what I found. The juvenile had not been served with papers. The parents had, but he was not served. So I filed a motion to set it aside. It was overruled by the juvenile judge, and he was a juvenile at the time. Became an adult, was transferred to be tried as an adult. We tried it before Judge Hippo Garcia, who overruled our motion because of the failure to serve. We got convicted. Shirley took it up to the Court of Criminal Appeals, and I argued it, and it was reversed. It came back. By then he was an adult, not subject to the juvenile court, could not be brought back and tried as a juvenile, and we had a checkmate, and he was turned loose, never tried again. And that's why I've got Shirley on here as one of my role models, because she can read the fine print on the fine print.
Well, you brought up role models. That's a good victory, by the way. You're proud of that one.
I'm proud of her, yeah. I had some more that...
Yeah.
I'll tell this quick story about the Travelodge. There was a murder in one of the apartments near the Travelodge, and there was an eyewitness, the only witness, a woman, and was put in the Travelodge and stashed away and told not dare leave there until the trial was over. Well, she didn't. And the prosecutor, I won't name his name, but they had the murder weapon, and he forgot to introduce ballistics. I rested with the state. I gave her a real hard time on cross-examination and just destroyed her. I got an acquittal. That was on a Friday. And on Monday, the proprietor of the Travelodge called the prosecutor and said, when are you going to let this woman out of this hotel? I said, she had a big party over the weekend and wrote up a $400 bill. So they were going to prosecute her for theft. And she called me and wanted to know if I'd represent her, and I said, sure, that'd be a lot of fun. So I went and talked to the prosecutor and decided they'd just drop the whole thing and chalk that up to business, you know.
Well, you mentioned your wife Shirley is a role model, and that's something that you and I knew we'd talk about, because this is the mentor committee. And the question is, what can a role model do for somebody? Did you have a universal role model at different times in your career? Did you have several role models? Did you have any role models besides your wife? And how were they a role model for you?
May I pass these out?
Sure. Now, I'm not asking you to name all of them, just
I know, but
a few,
I, through my career, have never singled out any one individual that I felt was a role model, because I feel that each person is an individual. We have our own talents, we have our own idiosyncrasies, we have our own style, our own personality, our own voice, like Warren Burnett, the most magnificent voice next to James Earl Jones I ever heard. And so to say that you've got a role model that you're going to try to emulate, you just can't do it. You've got to be, but you can take from an individual, just like from Jerry Spence. He is absolute one of the great trial lawyers of all time. I've heard him talk about opening statements and jury argument. And so a role model to me is someone who has a certain something about him that, or her, that you feel that you would like to not necessarily copy, but sort of put in your own mix of personality. I've got my dad on here. He wasn't a lawyer. He was in the furniture business, but he was the smartest man of integrity I ever knew. And he instilled in me an absolute, inviolable, be a man of your word. And so there's others. Shirley, for example, man, is she a lawyer? I shouldn't, she's going to hair lip me when I go home, and even talking about her, but it's true. On here is Bob Barton, who used to be district attorney over in Kerrville, a fine district attorney. He became judge, very fair. He could control the courtroom with just a look, and looking over those half glasses better than anybody I ever saw. Many others are not necessarily individual role models, but a composite of all, like I've said on this here. If I could have had pictures of them and overlaid them, I'd have a wonderful montage of role models.
Well, what about mentors? Do you make a distinction between a role model and a mentor?
Well,
and did you have a mentor or mentors?
Just about every one of these on here was a mentor in one way or the other to me. Like John Watts, when I was with him in Odessa, his jury arguments and opening statements were classic. What he could get by with in jury argument just mesmerized me. Jim Barlow, one of the great DAs and judges, he and I prosecuted Bobby Ray Davis, who killed a man and his wife over at the Rabbit Habit over here by the park. And during his argument, he did something I would never have the guts to do, but it showed you can be innovative. During his argument, he noticed one of the jurors was nodding off to sleep. He'd bob his head up, and Barlow just couldn't take it. So he took his hand. I don't want to do this, I'll break the glass. He slammed his foot on his hand on the jury rail and pointed his finger at that sleepy juror and said, "Listen to me, buddy, this is important. Now you stay awake, you hear? You talk about a jurors whose eyes looked like 2 fried eggs the rest of that time." We got a conviction, and the juror didn't seem to take it against him. But there's so many more here.
I'd be afraid to try that.
Huh?
I said I would be afraid to try that.
I wouldn't try it at all. I wouldn't try it.
It'd be more like a "please wake up, sir."
I believe I just ignored it and talked to the other 11.
We have some lawyers in the room that are just starting out, and in our program, as you know, they've been out 3 years or less, so we have anywhere from 0 to 3-year lawyers in the room today. Let's talk about what it's like to have a solo practice. Now, have you ever had to do that, or have you been able to have a partner or a firm that you were with?
I've had them all. With Alan Lancora, we were associated together. Freddie Seman and Lionel Goodstein and myself and Sam Bashara and Van Healy and my wife. We were all practicing there for a while. Then I've had more time been a solo practitioner than otherwise. And old Luke Souls, who's a great lawyer now with Buddy Benack, he and I and Bob Reed, Susan Reed's now deceased husband, we were partners for a while. And John Markey up in Billings and Helena, Montana. We had offices in Billings and in Helena. John had been the lawyer for the Oil and Gas Commission, and he was an expert on SEC filings. And he was one fine lawyer. And so I've had mostly solo practice, but I have worked for an insurance lawyer, I've worked for PI lawyers, I've had 1, 2, 3 partnerships, always go back to being by myself.
Well, what would be the most important advice you could give to a solo practitioner now, a new one?
Anchor your feet and stay put, and don't run all over the United States trying to build a new practice.
Well,
anchor yourself and dig in, join different bar associations, meet a lot of folks, meet people, do like I did in Wichita Falls. I didn't have any practice. So we had an Atticus Finch balcony there in Wichita Falls. And when I first started practicing, I don't know how many hours I spent sitting up there watching people try cases. Clyde Fillmore, the best district attorney I ever saw, he was a prisoner of war for 4 years, and did he know how to cross-examine? I watched him. I watched Bill Ballard. I watched Shields Heiser one time up there. He was trying a criminal case, and someone had left an abstract, a title about as thick as a San Antonio telephone book on the counsel table. And he was cross-examining one of the state's main witnesses, and he picked he picked up that abstract and walked over toward him and shook it at him and said, "Are you going to keep that testimony in face of this document?" And the guy just cratered, and the judge called his hand on it, and he went and sat down. And "Don't do that again, Mr. Heiser." Well, in his argument, he told the jury, he said, "You know, if I could have just let you see this document, I think the whole thing would turn out different." Well, that cost him $100, and he got an acquittal. So, you know, advice on a solo practitioner is dig in, meet a bunch of people, build your practice along the appropriate line. If you're going to be a civil lawyer, learn all the rules. For God's sakes, learn something about no evidence summary judgments. And get yourself a good secretary. Go to all the bar meetings. But do not neglect your family. Do not neglect your children. Prorate your time so that you have a balance.
do you think it's possible to really build a good practice and not neglect your family today?
Yes, sure do. It's a matter of, you know, they say a busy man can get more done. You want to get something done, hire someone that's busy, you know. Yes, I believe you can. I just, it's a matter of assignment of responsibilities. Recognize them. I regret that I spent an awful lot of time away from my family when I was in Montana, because I had a partner and another partner, and we were running around all over the country picking up oil leases. And it took me away from my family, sometimes several days at a time. And first thing you know, your kids grow up, you know, grow up. And your wife is, I would simply say, if you're going to be a lawyer, whatever you are, don't neglect your family. Just find time to, because you'll be glad you did. Another thing about being a solo practitioner is that your overhead, you have to swallow all your overhead. Pat Priest, Judge Priest, one of the great judges, office next door to Fred Cement and I in a Tower Life building, and he was a solo practitioner. Well, he got Tony Cantu to come in there with him, and then one day Pat came in and he said, Charlie, said, you know, I'm going to see if I can get me a bunch of my friends together and kind of share ideas and split the overhead and see how that works. So he got Tony Cantu, he got Nick Rothy, John Hernser, and a couple of others. And they went together and they sort of cut down the individual overhead. But if you do that, you want to get people who are compatible and that will pull us with you. But being a solo practitioner has its merits and it has its drawbacks. If you're a solo practitioner and you go to trial, why ain't nobody watching the store while you're in trial? If you're out of town, same thing.
You and I talked earlier about advertising, Charlie. And my feeling, I've been thinking about this for quite some time, and I forget when advertising became approved, but it was a freedom of, or First Amendment right to speech, I think, and it went before the Supreme Court.
Yeah.
And I'm going to say it was in the 70s. I'm just guessing. Anybody dispute that, maybe? But I often wish that I could be a lawyer before advertising was allowed, because the model then would be if you joined this club, joined that club, and participated in the community and did a good job, had a good reputation, business would come to you. But now, to me, advertising is maybe more about who is the best advertiser. I don't know, but I wouldn't mind practicing law without advertising. But tell us your views. Do you think advertising has made a big difference in the practice of law?
I think it's an abomination. I was on the board of directors of the state bar. I lost my voice here. What do I do with it? I was on the director of the state bar when the Supreme Court case came down, and I was on a committee to fight lawyer advertising with the bar, and of course we lost. On the old Joe Fraser Brown used to teach ethics out at St. Mary's, and one day when advertising was had just come in while I subbed for him, and I took an empty bottle of champagne with me out to the, that's when I was teaching there, and I told his students, you know, this lawyer advertising is going to become an absolute nightmare. The lawyers who've don't even know how to find a restroom in a courthouse are going to be getting to be judges, and they're going to be advertising, and it's who can spend the most. And I said, I want to just give you an example of something that may happen. Suppose it's a divorce case. And I said, you're going to get some slick actor like they have on that Working Man is going to lean into the camera, and he's going to set this bottle of champagne on, and he's going to say, are you lonely? Your husband mistreating you? Call me and we'll get the divorce and we'll celebrate, honey. And it's almost come to that. You see the buses going up and down the street all the time, and it's not just here in Texas. Everywhere I go, I get the yellow pages and see all this outlandish stuff, and of course it's here to stay.
Well, how did?
But I just am against that high-powered advertising. I just am.
So you're against it.
Absolutely.
And how do you think it has changed things for the solo lawyer?
Well,
From when you were there before advertising, how do you think it has changed how we would have to practice now? Maybe our relationship with our clients or with other lawyers? What do you say?
Well, I don't know. Really, I'm glad I don't have to figure it out. But I just don't know how a solo practitioner can combat the advertising that goes on, especially in the PI and the criminal cases. You don't see that much advertising about real estate, oil and gas, even family law you don't see as much. But it'd be tough. It'd be tough to open a solo practice without doing some kind of advertising. Even if you get a website, you got to figure out a way for someone to dial it up, you know. And but I'm a big believer in the old way of building a practice, but I don't know whether it worked too well now or not.
Okay, I'm going to ask you, Charlie, for a specific thing, advice to the you can give it to all of us, but the newer lawyers in particular, for those who are trial lawyers or who are not trial lawyers even, your advice for them on getting along with other lawyers. What should they strive for?
Courtesy. Be courteous to your adversary. If he or she does not reciprocate, be very courteous to them. Don't try to lower yourself to their level. If, for example, in the trial of a criminal case, the prosecutor refuses to call you by name, just refers to you, says the defense attorney, the defense lawyer, just politely say when you get the opportunity, you know, yeah, I'm the defense attorney, but Mr. So-and-so, the prosecutor, he has a name and I do too. My name's CharlieButts. And don't fall into the trap of name calling. And in the course of the trial, be very respectful to opposing counsel. If they aren't, well then the jury or the judge will know about it, will recognize it. Rambo tactics. Man, I hate Rambo tactics on discovery. There's one lawyer here in town that I had a case with, and he liked to wore me out. And the minute I filed something, here comes something else. This was in the employment field. And so I would say just reciprocal courtesy, plain old-fashioned courtesy, and no name calling will go a long ways toward lawyer relationships.
All right, let me ask you a similar question. The single piece of advice, the best advice that you like for lawyers on client relations, based on all your experience.
Keep in touch with your client. That's one of the most neglected things I think that lawyers do is they get a case, they don't give the client any clue about what's going on in the case. Judge Cassett told me one time that he had a practice of everything he filed, he sent a copy to the client. Everything, clients, lawyers, letters, pleadings, the whole bit. That way the client knows what's going on. You run the hazard, however, of them trying to become a lawyer and second guessing you from the papers. Another thing is don't fail to return phone calls with your client. Remember the attorney-client privilege. Someone calls you up and they want to know all about the case, even if they say they're a relative, just very politely say, I'm sorry, I can't talk about that. I had a call just about 3 days ago from the Department of Child Protective Services out of Austin. Said, Mr. Butts, I understand you represented so-and-so such and such a year in this child abuse case, and I wish you could tell me what it was all about. Hey, wait a minute. I know you're who you say you are, but I can't do that. She got real hot and hung up. So your attorney-client privilege stays with you even after your case is over. There's a lot of problems between lawyers and clients where the client wants their file. The lawyer thinks that's his, but it's not. It belongs to the client. You have to always get I make a copy of it and get a receipt, but sometimes that's kind of costly, but it sure saves you hide.
Okay, and I'm about down to my last two questions. Charlie, now you've been in front of a lot of judges, and this is one actually for me. What would you recommend when you're having an oral argument? It could be an argument at the bench in a trial, or it could be at a hearing just on a motion, and you think you're losing, and you think you're losing the judge. If you got any advice in your hip pocket, what you do in that instant?
Losing the judge in what respect?
The judge is going to rule against me. You just don't think you're doing that well in the hearing.
I don't know what you do. Just keep on trucking, I suppose. You wouldn't want to say, "Hey, Judge, am I losing you?" I don't know how to answer that question. I really don't. Sometimes you get a feel, all hope is gone, but keeping the record clear that's one thing in the trial cases that lawyers don't do. They don't push that record to a definitive adverse ruling. And some judges, that one thing I don't have in this, but they'll say, you make an objection, they say, well, the jury will remember the evidence. Counsel, stay within the record. Let's move along, they'll do that when you, and it will not, young lawyers, or all of us, should insist on a definitive finding. If the rule's with you, fine. If the rule's against you, then ask for another ruling. Try to keep your record. If they've ruled for you and you think there's enough prejudice there, why, say the court's done what it can, I respectfully move for a mistrial. But get yourself a definitive finding, We had a judge now that's no longer alive that had a great habit of saying, move along, counsel, let's move along. Warren Burnett was trying the case in front of him, and Warren had a personality that could really get under your skin in the trial of a case. A wonderful lawyer. This particular judge said, let's move along, counsel. We've got to move along. Warren stood up, and I'm sure you've heard James Earl Jones' magnificent voice in the movies. Warren stood up very deliberately and said, well, Your Honor, I would appreciate the court telling me where I'm to move to. And I would also appreciate knowing how fast I should move. If the court would tell me that, I'll certainly comply. I understand the judge nearly busted a gut, but the judge, he got by with it, you know. So, but a lot of judges will do that, and they'll try to. I don't know that it's necessarily a mean spirit in their mind, but they've just got that habit. And one of them, and I'll never let it go by, said the jury will remember the evidence. No way.
Well, you've got to really stand up for your client, don't you, when you're in front of a judge?
I went to jail doing it one time.
I mean, it's tempting to give in, isn't it, because you're always thinking of the next time you're going to be in front of that judge. Has that happened to you, where you're tempted to give in?
Well, William Kunstler is the classic example of a guy hanging in there against an oppressive judge. You've got to remember that if a judge is picking on you as a lawyer, he's actually striking your client over your shoulder. And it sometimes takes courage, but if you say, well, Your Honor, I object to that, the court's attitude and the words and tone and all is prejudicing my client to a fair trial, and I want the record to reflect my objection to it. That takes some pretty good courage if you've got a real tough judge, but you've got to protect your client, that's all. And so many, I don't know, so many lawyers this day and time, I won't say younger lawyers, but so many lawyers don't realize that when you've got a client, he's your client. You took it on come heck or what, to try him or defend him or whatever to the best of your ability under the rules and the law and the ethics. And a client is a client. A lot of people don't realize that.
Charlie, what happened when you almost got thrown in jail?
I wasn't almost, I did.
What happened?
I was trying a case in federal court, not one of the current judges. And my client had been going with this girl, and they had a baby between them. And she denied that the child was hers. And I had an 8x10 glossy color photograph of the little boy. He was the spitting image of my client, and it was her little boy. So I had it marked, and I said, now, you had this little boy from my client. No, she got so mad, almost cussed me. Well, I made a mistake, I must admit it, but it was unintentional. I swear I didn't deliberately do it. I had it like that. It had been marked, and I was going to hand it to the court reporter. And I said, so you recognize this, don't you? And of course, when I did that, the jury, and I handed it to the clerk. The judge just went berserk at me. And he said, mark that. I said, well, Judge, he got me a little bit rattled. He shouted at me. Mark that, don't you ever show anything with that? And I said, well, Your Honor, I apologize. No, you don't talk back. You shut up. And he shouted at me to shut up. And so help me, he took his fist on the bench and said, shut up, shut up, shut up. And then's when I did what I said a while ago. I said, Your Honor, I respectfully object to the court shouting at me and telling me to shut up, because that's hurting my client with this jury. Well, I told you to shut up. Now you shut up one more word and you go to jail. I said, let the record reflect that I can't speak. Marshal, take him away. So, it was in the old federal courthouse down the old post office, and it took me to put me in the marshal's holdover. I wanted to have some fun, so I had a pretty good sized pen. I started banging on the bars. It's noontime. I demand some lunch, and I want my phone call. So I called Freddie some man. He got a hold of Judge Spears, and I stayed in jail till after 2 o'clock. And so it was in the days when they had the old gray autograph. It's a round blue disc instead of the stenotype, and it had audio on it, and I wanted that audio about them words of shut up, shut up. The court reporter said, you know, I didn't have that turned on at that time. I said, yeah, I bet that's right. So anyway, I got out and I hired the best lawyer I knew, and Shirley took the case up to the Fifth Circuit and reversed it on contempt. The order of contempt simply said of accumulation of disrespectful remarks in the course of a trial, he goes to jail. The appellate court didn't buy that, and they reversed it, and in order to try to show what had happened, they footnoted all of his remarks, and it was reversed. But he was a good man, a good man. I tried a case not long after that in Del Rio, got an acquittal in a drug case, and when it was through, I was feeling pretty good. And I hear this stern voice from the bench said, "The court will seek counsel in chambers immediately after the jury." I said, my God, what have I done now? I went in there, he shook my hand, said, "I want to tell you I'm proud of your accomplishments in the bar. I congratulate you on this victory, and I want you to know I had a bad day that day, didn't I?" I said, "Yeah, that's two of us." And we became the closest of friends, and he demonstrated a real fine character by recognizing that it was a bad day, you know. Here again, it spotlights what I've said. You've got to treat the court with respect, but in all, don't be afraid of cat. Protect your client.
I love that story, Charlie. We're out of time. Maybe there'll be a part 2. It's been an honor for me to
Pleasure.
be able to talk with you and ask you these questions today.
Thank you.
And with that, we'll close.